Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started. Hi, April Jones. We just now started recording. We are on today for one of my favorite topics, which is child custody in Colorado, and just a guide to it. We do family law. We have since 2000. I am joined by David Collins, Morgan, and Haley. They are all senior attorneys at Jones Law Firm. They're amazing. Hey, just while we're introducing ourselves, David, introduce yourself. Say a little bit about you and why you care to help people in custody situations, and then we'll just go around the Zoom room, and then we'll start with our questions for today.
Thank you, April. Good afternoon, everybody. My name is David Collins. I am an attorney working for April. I've been practicing for 20 years now. I have always worked on behalf of children, youth, and families, including the decade before I became a lawyer. So for me, it's always been a natural fit as a lawyer to advocate on behalf of families.
Thank you. Morgan.
Hi, good afternoon, everybody. My name is Morgan Terrell. I am also one of April's attorneys at Jones Law Firm. I have been an attorney for 10 years, and I really enjoy helping people go through what can be sometimes the most difficult and emotional time in their lives, and really helping try to guide them through that as best I can. So that's why I do family law.
Thank you, Morgan. Haley.
Hello, my name is Haley Hollins, and I have been an attorney since 2016. And I actually knew in law school that going into family law was something that I wanted to do. And I focused my coursework and have exclusively practiced that since getting out of law school, and have really enjoyed being able to help people transition through really difficult times and to actually see that you can make a difference and help people through something that a lot of times there's no guide for. We're really blessed to get to do that.
Thank you. And we are really blessed at Jones Law Firm to have all three of you, to have a team of people who care about helping other people. So let's jump right in. We have questions that were submitted in advance by our attendees. Our attendees will not be able to see each other, but we see their questions. You can submit questions while this panel is going on. And then also we're going to be answering questions that we hear all the time. So we can just make sure we cover as much as we can this hour that we have. Okay, so a top search question and a top question that we get asked is, how do you get custody in Colorado? All right, so we're gonna just take a moment and just give a quick overview of the process of how do you get custody in Colorado. And why don't we answer this question as if they were not married, because it's the same except just slightly different. So David, why don't you give a quick overview of how do you, quote, get custody in Colorado?
Sure. Thank you, April. In Colorado, if you're not married, the process of seeking a formal court order that would determine parenting time and other issues is called an allocation of parental responsibilities case. The parties are basically telling the court, we are two people who have a child together, and that could be a man and a woman or a same-sex couple. It doesn't matter in Colorado. And you're asking the court to make determinations about parenting time, which literally means where the child resides 365 days a year, so overnights. But it also includes major decision making for the child or children. So major decisions would include things like where the children go to school, whether they have medical procedures, and other major decisions affecting the children. And then the third prong of that would be a determination of child support. And then for that, the court orders the parties to submit financial affidavits and statements so the court can understand what the parties earn. And with that information, the court can enter an order for support if one party is substantially out earning the other, or other criteria come into play.
Thank you. And one thing we do get asked, people think that they have custody, they've determined custody based on how they interact with we'll just say your ex. You share custody you let your ex have parenting time every other weekend, and then you think, okay, we have custody arrangements. Well, you do in an informal way that is not enforceable. So as long as you're getting along and everybody's doing what they agreed to and nobody has any problems with it at all, including new girlfriends, new boyfriends, new wives, new husbands, grandparents. Like you need a lot of people. Your barber says, "You're only getting what? You're only doing weekends. You're a wonderful dad. Why aren't you doing more?" Now you have a problem. So your opportunities for problems are, as close as your next Uber driver who says, "You're doing what?" And then you have something that's not enforceable. You have to now, after the fact, go to court, file what David was referring to, this petition for allocation of parental responsibility, where the court, not the parents, the court allocates responsibility for parenting based on, as David said, the 365 days and nights available for parenting. So the court will allocate who has the child when, and then makes it an order of the court. That is how you get custody orders. Morgan, anything you want to add? Because there's a lot there.
There is a lot there, and there's a lot of potentialities, I think, for these types of cases to come before the court. And the only thing I would add is I have seen courts sort of take into account what those informal arrangements have been. So even if you don't have it formalized and you're kind of going through the process now, it's important to be able to tell the court what the parenting time and visitation schedule has looked like so that the court can take that into account and we're not uprooting or really creating turmoil for the children. So I do think that even if you don't have a formalized parenting plan or visitation schedule by the courts definitely will still look at that as sort of a
Absolutely. So important to point out, Morgan. What she's describing is what we refer to as maintaining the status quo. So you don't have court orders. You can't call the police and say, "Have my child returned," because the parent's doing more than a weekend. But you can, once you file with the court, once you're in front of the court, we would present what you have been doing as the status quo. We would ask the court to maintain the status quo unless we don't like it. Then we would ask the court to absolutely not maintain the status quo. But that is how it is used. The court will oftentimes, as Morgan was saying, rely on it because it just met you in 10 minutes. It's got to do something. Well, you guys have been doing this, so let's just keep doing what you're doing while the court has an opportunity to get in and look at it closer. So that may or may not be the case, but it's likely what happens. So the status quo is very important. So you don't want to get yourself backed into a status quo that you don't like, that you don't want to be stuck with until we get to court again. If I was preparing a case and nothing had been filed, I would be saying, look at the status quo that you are creating. And do you want to be stuck here for some time once the court is involved? Anything you want to add, Morgan, to the question of how do you get custody in Colorado while we give out this quick layout of the process? Do you see anything else you want to add?
I think David gave a really good sort of general idea of how a case sort of works its way through the court system. Of course, there are some other sort of ins and outs that deal with families and their particular situations because every family we see, every child we see, every couple we see are all different. And so there are lots of different things that we can do within the court system to account for everyone's individual sort of scenarios and individual families as well.
Thank you. Haley, anything you want to add before we move on and start taking questions? Anything that you think would be for our listeners?
And just the only other thing to consider when you're talking about establishing a child custody order is to understand that the court will likely require mediation before you all enter a courtroom, but that if you and the other parent have no agreements on any of your issues, that litigation is an option as well. It's important to discuss kind of your options with an attorney to figure out exactly if trying to settle out of court is right for you or if that's just something that you know isn't going to be right for your family.
Thank you. Let's go ahead and jump in with questions. I have one here. My ex-husband and children's father has drug and alcohol addiction. How likely is a judge to enforce sobriety? How likely is a judge to award full custody while sobriety is established? Jump in, David.
Sure, thank you. That's a great question. It's a common occurrence in our caseload here at Jones Law Firm. I currently have several clients on monitored sobriety, and I also have cases where I've sought monitored sobriety for the opposing party. Uh, the way to go about this would be to ask the court generally for a substance abuse evaluation of the person who has the issue. If the court believes there's an issue, the court will order that evaluation and then order the party to follow the recommendations, which is often monitored sobriety and drug and alcohol counseling and therapy. It may not be likely for the parent to be kept from the children while they're in this program if they're sober. So if someone is succeeding in the program, the court is likely to let them reunite with their children and maintain their parenting time. It really becomes a problem when a parent misses UAs, which is a urinalysis test, or has a hot test and tests positive for whatever the issue is, drugs or alcohol. And then a judge may be inclined to temporarily suspend a person's parenting time till they can establish a period of sobriety. What the courts don't want is a parent under the influence of drugs and alcohol during their parenting time. And I've had judges say, even though it's legal in Colorado to smoke marijuana and drink alcohol, I am ordering you as the judge in this case to not consume it before or during your parenting time. And so once that happens, a party has a choice to make to give up their addiction, which can be very difficult, and keep their children, or to not give up and possibly give up access to their children.
Thank you. Morgan, as a public defender previously, what are your thoughts and what would you add from a family law perspective?
Absolutely. I would add that there are numerous ways that you can go about requesting substance abuse monitoring, depending on what your particular concern is. We have a lot of both private companies in Colorado who offer those services, and to the even further extent, if they've been charged in some kind of criminal case with, a DUI, for example, or being under the influence or possession or whatever it might be, they might be under formal supervision. And then you can request to have access to those as well. So we have lots of different tools that we can use to either make sure that an opposing party or parent is staying sober and can maintain that sobriety for long periods of time. So there are lots of options for short-term in the moment testing, for example, right before they're starting their parenting time, or looking at what their longer history of substance abuse has been, even going back to 6 months or so. So we have lots of tools to sort of request from the court that the court can institute or put forward in a plan, like David was saying, or a recommendation to the opposing party if they want to keep their parenting time.
Absolutely. And the court, depending on what the substance is, what the frequency, what the allegations are, what the extent of the abuse, of the misuse, there are different options. There's hair testing, there's blood, there's urine testing that can be ordered at a certain frequency. There's random testing where you get your number comes up and you go test. You can't have your parenting time until you do. There's breathalyzers that can be on your car where you have to blow into it in order to start your car. And there was a time when people would ask other people to blow into it. They do that in the movies and they did that in real life. And now their breathalyzers have cameras. So you've got the breathalyzer, you blow, you've got the camera, the other side has access to it. So there are a lot of different tools that you can use simultaneously, separately, depending on the extent of the abuse, the extent that you think the person is, the one inclined to have not be the one who uses their own pee in the cup, the one who's going to not breathe into the breathalyzer. And there's also the one who's super sorry and they're going to do everything by the book but they still might miss. So there's just a lot that goes into it. But that's why it's so important to have a good attorney, to have somebody who has experience in this so that you can tailor your solution to your person in your situation. Because as you can tell from the list that I just blurted off the top of my head, there are so many ways this goes down. We had a client, and I used to, it seemed like I said it wrong, but it wasn't wrong. The the parent would let the child drive when the parent was drunk. So the parent wasn't driving drunk. The parent was driving, well, was letting the child drive on his lap while he was drunk. Um, so that was a problem. But there's so many different ways for this problem to show up, and we've seen most of them, I hope. And Haley, anything you want to add before we jump to the next question? I love these questions,
I
so
think
just
you all
keep them
covered
coming, guys.
I think you all covered it really well. The only thing that I would say is to focus on your perspective as the client in this situation, that a lot of times the process will not be able to change this person's substance use disorder. They may, like you said, snap to it and realize they've done wrong and want to follow everything in line. But you may be dealing with someone who's going to be having this disorder and using substances or alcohol moving forward. And so all of these tools that we can put in place to establish the parts that we are in control of, because that person's recovery is going to be their own path. But what we can do is help you figure out the things that we can put in place to help protect the kids as much as possible.
New question. I work full time. My soon to be ex-wife is a stay-at-home mom. They have 2 kids under 2, so under 30 months. When custody arrangements are made in the future, this dad wants to have 50-50. So his question is, will I be able to get 50-50? Can I choose to reduce my workload so that I can be available for my children 50-50? He's saying, why should I have anything less than 50% custody when mom could go back into the workforce at any time, even though dad makes enough money? So there is you know what, Morgan, why don't you jump in and take this? I want to spread the answers around so we get different perspectives and then add to them.
Sure, absolutely. And that's a great question, and one that we get from our clients who are fathers all the time is mom going to get preferential treatment from the court simply because she's mother? And the short answer to that is no. The courts very much operate from a stance that mom and dad are both equal and are both entitled to equal parenting time. That's sort of the starting place and the jumping off point for most courts. Of course, sometimes we have reasons why 50-50 may not be appropriate. Sometimes it's something more more like substance abuse. Sometimes it's something a little bit more simpler with work schedules, like this question is referring to. And so there is one caveat that I'll bring up. So when kids are under 30 months, like April said, the courts do tend to look at those cases a little bit differently just because the children are so young. But by that, I don't at all mean that a father can't still have 50-50 parenting time or 50-50 custody of the children. It's just one of the many factors that a court will take into consideration. And if it's reducing your workload and that opens up your schedule more to allow for that, and there's no other reason that's presented to minimize or give the father less parenting time, there's no reason a court can't award 50-50.
Absolutely. Haley.
Yeah, I think that Morgan said everything on that really appropriately, and that the court does not favor mom over dad. I actually end up representing a lot of dads because that's something I feel very comfortable relaying to the court, that if a dad is comfortable and ready to be there as an equal parent, then unless there's any other reason why not, then it's something that you can pursue. I usually do caution clients to go after the hard line of 50-50 on time, because it's sometimes important to roll back and think, when is the good parenting time? If you've got school-age children who are going to be in school from 8 a.m. to 3 p.m., and we're talking about those evenings, or when your work schedule is, it's important to come up with something that's not cookie cutter, because no one's family is exactly the same. And so that's one of the good reasons why it's important to come up with a plan with your attorney that could actually work for your life. I think getting caught up on percentages can be a dangerous game that can sometimes be on principle, but in reality, equal parenting time is usually what is healthy for children based on a lot of the research that I've been exposed to.
And there's so many different ways to do it. There's there's week on, week off. And then you could say, my children are too young. They're under 2 years old. That's too long. And you'll get the experts saying that that's too long for a parent to be away from a child, unless you do it voluntarily. But then you have something called the 5-2-2-5. So you take a week of 7 days, and I'll just make it easy. Every Monday, Tuesday would be moms. Every Wednesday, Thursday would be dads. And then you rotate the weekend, and that's where you get the 5. So if you have Wednesday, Thursday, you'd have Wednesday, Thursday, Friday, Saturday, Sunday, and that's 5. If you have Monday, Tuesday, you have Friday, Saturday, Sunday, Monday, Tuesday, and that's how you get 5. That's why we call it a 5-2-2-5. One week you'll have 2 overnights. The next weekend you would have 5 overnights, because you take the weekend and you stick it next to your 2 overnights. The value for that is that even if it's an overnight, you can see your child in the morning. When you get the child, you have an overnight. Then the next day you get to see the child when you say goodbye to the child. So there's this kind of constant access and flow. There's 4-3-3-4s where you do 4 nights and then 3 nights and 4 nights and 3 nights, and the days always change. Some people love that. Some people can't keep up with the days. Like, I personally would need my dates to be like Monday, Tuesday, because I have so much going on. If somebody invites me to something, I want to be able to say, oh, it's Monday. I have every Monday. I can't go. Unless it's a kid thing and it's a Tuesday. I have Tuesday. I can always go. I don't have to say Monday, Tuesday, Wednesday, Thursday, what's my day? But some people love that. So it's really personality dependent what you end up with. And there's many schedules. So that is a lot to look at. And you look at it with from the standpoint of you, your ex, and your children, and what everybody's kind of personal disposition is. Some children don't even know where they are when you do a 4-3-3-4. And they need to be able to say, is it Monday? So just depends. David, what do you want to add?
2 quick things. One is that it's really common in a marriage. A marriage is a team, it's a partnership, for one parent to work full time and the other to stay home and raise kids, especially for kids under 3 before they hit preschool. But the judge isn't going to say, well, Dad, since you went to work every day, you probably shouldn't be an equal parent. The courts really don't do that. And the second part of my answer is childcare. The court understands that everybody that works has childcare. Most of our clients are in 2-parent working households, so they already had childcare when they came to the table. But if you only have one working parent, that parent can absolutely have childcare during their parenting time for the time of the workday where they're not available. And as Haley said, school gets out at 3, but we don't get off work till 5 or 6. So there is that gap, and that's why there's childcare. And for children under 3, there's preschool and there's family childcare homes and all sorts of settings for children under 3 where you can have childcare during the workday if you're working. Thank you.
Yes, thank you, David. We have another question here. It's a common question. Do children's preferences play a role in determining the custody split? In my case, it's a 6-year-old who can be swayed easily to like one parent more than another if candies, toys, etc. are at play. I had a case once where the dad was saying, this is my client, was saying that the child was reporting that they wanted to be with him, and he had it on video, and he had a little bowl of Skittles sitting in front of him while he was asking them the questions. I did not use that video. David, jump in and tell us what you want people to know about that question.
Sure. So in Colorado, the children do not get to choose. However, in Colorado, the court has to follow a specific statute. It's called the best interest of the child. That statute has 14 elements in it. One of those 14 elements is the wishes of the child if the child is sufficiently mature enough to express that opinion. In Colorado, it's extremely unlikely a child is going to be found mature enough to have that opinion before they're 11, 12, or 13 years old. And even when they do hit that age range, it's just one of 14 factors. As the child gets older, in my experience as a trial attorney, the preference becomes more important to the judge. If you're talking about a 16 or a 17-year-old child, in my experience, it becomes a much bigger weight for the court. But in general, children don't get to choose. It's wildly inappropriate for a child who's 6-year-old to choose at all. And in that same vein, the court will not hear from the children. The court does not want the children in court. Generally, the court will issue an order at the outset of the case saying, don't expect your child to be here because we don't want children in court unless you're ordered to. In a rare occasion, a judge will meet with a teenager in their chambers outside the presence of the parties to hear from that child. That is extremely rare, but it can happen. Otherwise, the wishes of the child will be articulated by a court-appointed expert who would have met with the child and then conveyed them to the court. What's really hard to do is convince a court that the child told you, a parent, what they want to do. The court is going to assume the parents are biased towards what they want in a case. So, telling a court what a child told you as a parent is not very persuasive to a judge.
Haley.
I think David covered a lot of really important points, and I feel like I'm always jumping in with words of caution. That I'm just sitting here thinking of things, but is to anyone who's considering if they would want their child to have a say in the procedure, is to think about what kind of trauma even being given the choice is to a child, even if they've got a choice, even if they have one in their heart. Making that choice or verbalizing that choice is something that can inflict a trauma on your child, and to consider that putting them in the middle of this process or even asking them is one of the things that the court is trying to prevent with this kind of thing. And so if you have real concerns that your child wants to convey, that child and family investigator may be the right path to have some additional eyes on your situation, but really allow your child to be a child if you can.
One thing I want to add, there are so many counties, right? However many counties there are in the state, and then however many judges there are in the county, that the judge wearing the robe talking to you that day will be making the decisions about things that are within their discretion. There's a judge colleague in Douglas who was bringing in children to interview them himself. He didn't see any problem with it. I was like, well, what ages? He's like 6, 7, 8, 9. It's like, oh, it's within their discretion. I was in court in Jefferson County and the parents were having a dispute about what the children should or shouldn't do. He took a break. He made us all go on break and said, have the babysitters bring the children into court right now. Both parents are crying. The judge is like, on break, bring in the children. So it varies, and that's just something to keep in mind. Generally speaking, the judges generally don't do it, but it is judge specific, and it is within discretion to make those sorts of choices. So that's just something to keep in mind when you're in this process. It's really important to get lawyers who know your particular judge, the particular person wearing the robe, the particular county, and how things are moving. Now they move judges all around too. It's like January in Denver, it's like judicial musical chairs. So it's something that's ever changing, and you need people who are in the game regularly to really be able to do what we like to do, which is strategically think about what your next best moves are. Next question. My ex-husband left the state and went to a football game on his weekend, the weekend he was supposed to have with the kids. He did that without regard to the writer's time. Is this person forfeiting his time with the children? Can she file for full custody because he left the state, went to a football game on his weekend? Morgan.
Yeah, and this is a question that we often get, unfortunately. And so here would be my advice, and David and Haley may have some other different advice, so I would encourage them to chime in. But the thing about having to co-parent with someone else, likely for many, many years, is that both of you are going to have opportunities or interruptions or other plans or, anything that may disrupt what your normal parenting time is. And the more that you guys are willing to talk about that with one another, discuss that with one another, and ultimately sort of work together to, trade when those weekends come up, the better it's going to be for you guys and the better it's going to be for the kids. Things come up all the time, right? And, and whether it's, a family member is ill out of state that you have to go and visit, or whether it's a football game, I think that my advice to parents is always to try and work together first before saying something like, you know, I want to file for full custody potentially, because ultimately, like Haley mentioned earlier, it's better for the children, at least, if they have equal time with both parents. And so taking away that, you know, sort of going at it from, I want a full custody parenting time and visitation schedule may not be what's best in the long run. My one caveat would be, obviously, if this becomes a pattern of behavior and not just one weekend, obviously that's something that we're more concerned about. And we would certainly, you know, my advice to you would absolutely be different. If it's sort of a one-off, you know, I would probably encourage a client to sort of see it that way, and, you know, maybe have a conversation with the other parent about communicating when they can't exercise their parenting time, or if they want to trade days or whatever it might be.
Absolutely. If it's a pattern, a different story. If then we're telling the story about this child who's sitting, you know, basically looking out the window, waiting for dad to come. Dad's promised him and promised him and promised him, and just doesn't show up. Well, it doesn't matter that it was because they went out of state for a football game, or they just didn't, or they stayed at home and watched football. If they are not showing up for their child with the regularity that makes it not in the child's best interest to have to go through that, then that's when you would file something with the court. If you file something with the court because they went to an out-of-state football game once, that's not going to go well. The point would be to communicate and say, hey, you need to let me know when you're not going to show up for your parenting time. Duh. And I will do the same. So the point is, we'd want to see your attempts to communicate before you say, I'm so distressed by it, I want the child all the time. So you got to think about the decisions you make when you go to the court, which again is why you talk to somebody who's experienced. Here's a question that we've gotten in different forms, so I'm going to jump right to it. It's, what is full custody? And so we have that question. We have, can I get full custody if the other side says they don't want parenting time? What is full custody, David? Is there such a
Sure,
thing?
thanks. So full custody in Colorado, the word custody was replaced with the words parenting time. They basically mean the same things, except for that in Colorado, one parent can have 100% of the parenting time. That doesn't mean the other parent has lost any of their rights as a parent. They can, in the future, come back and try to get some parenting time or increase their parenting time. It's actually really difficult in Colorado for a parent's rights to be terminated. That's a whole separate process, which we can certainly help with. It's also really hard in Colorado for a parent to forfeit their rights and terminate their own parenting rights. The courts are generally against that because they want the parent to support the child financially. So even if a parent wants nothing to do with the day-to-day life of raising a child, they have a financial obligation. So if you're seeking 100% of parenting time or full custody and the other side agrees, that's great. But you're still entitled to receive child support to support you in raising that child. And as the folks on this call know, raising a child is very expensive, and it's a bill that only goes up through their childhood. So that's the short answer. The last answer I'll give is, we do often represent couples who are divorced, who are remarried, and there's a step parent in the picture. There is a process for a step parent to legally adopt their stepchild, and in that process, the biological parents' parenting rights are terminated, either voluntarily or involuntarily. So if you're remarried and the parent of the child is disappeared and basically abandoned the child, your new spouse, husband or wife, can petition the court to legally adopt the child as a step parent, and then they become the parent of your child.
And then the other parent is booted out and is in fact terminated.
That's
So
right,
when
and
people
no
come in,
longer on the hook for child support. Sorry.
right? When people come in and they're like, I want full custody, and you say, what does that mean? Are you saying that of the 365 days and nights available for parenting, you want 100% of them? You don't want the other person to have any at all? Not a birthday, not a Christmas, not an hour. And I would say 99% of the people are like, well, no, they can at least have an hour, right? They can at least have birthdays, they can at least have Christmas, they can at least have holidays. So that's how we explain full custody. There's 365 days and nights available for parenting. The judge divides those up. That's what we call it, allocation of parenting, and what is to be allocated for you and what is to be allocated for the other party is how it's divided. So full custody would mean the other person just had just zero. And like I said, most people don't truly want that. Next, we'll do one more. Should I be worried allowing my ex to see our child on my parenting time, play dates, movie nights together, etc.? Will she be able to use it as an argument for claiming more than 50-50 because our children technically spend more time with her because mom is coming over to dad's and having parenting time at that when dad's hanging out with the kids and parenting his own kids? Haley, what do you think?
Well, it depends on how much of a pattern you're establishing and how much time you're really giving away to mom. Pardon me. But I would caution you in framing this on if you should be worried, because the court's going to want to see you all kind of fluidly allowing parenting time and possession to happen if it can happen organically, where you can allow more time on your time and that time is really just the child's time with their parents. That's appropriate. And so I suppose that in the terms of if you're concerned about your legal position and giving up any kind of forward thinking time, would be that to limit what that is. If you're not gonna, don't give away 3 weeks in the summer if you've got it to mom. That could look like you're, forfeiting any kind of right. But all that to say is that the court is going to want to see that encouraged co-parenting of you all working together. And so I don't think that that's so much that you should be concerned about in allowing those additional playdates or movie times, but just something to consider, the frequency, duration, all of that. But it doesn't sound like you're near treading any kind of dangerous territory on having given over anything to her. But that's a good question. I welcome anyone else's comments on that too.
That's a good answer, Haley. I want to jump to this other question that's been sitting here. It's someone, him and his wife separated in 2016. The wife took the kids, moved to California. They didn't file for divorce. They didn't file anything. So remember what we talked about at the outset. If you haven't filed anything, you don't have court orders. You've got a status quo. Now, one thing that's different in this story so far, if you've moved to California and the children have been residing in California for, over 182 days, Colorado no longer has jurisdiction if they have become California residents. But the question doesn't stop there. So mom then contacted him and said, can the kids live with dad for a year due to financial reasons? So now the kids got sent back to Colorado. I can't quite tell from the question, but it sounds like they've been living with dad for a year. Well, now if they've been in Colorado for 182 days, Colorado has jurisdiction and California has lost jurisdiction. And this writer wants to file for custody, which you need because you have no custody orders at all. So even if you wanted to just preserve what you were doing because you both thought it was wonderful, you need court orders. In this case, he's got issues with how the child, the 10-year-old is reading at a kindergarten level. They're not doing well in school. He's been getting them situated here in Colorado. File in Colorado immediately. You don't want to lose jurisdiction. You don't want mom to take the children, go back to California, say, hey, I was sick. You kept them for me. Thank you so much. And now you can't even find me to serve me until after it's been 182 days in California. And now they're California residents again. You don't want to get into those games. Definitely call us and let's get you filed. Let's file something immediately. I mean, obviously we need to talk about more facts because as you said, you can't put that in here. But yeah, time is really important here. It sounds like time happens to have shifted to be in your favor, but you need to act now. All right. So thank you everybody for joining us. Thank you for all the attendees. David, Morgan, Haley, love working with you. And have a happy holidays, everyone. We'll see you next time.
Happy holidays. Thank you.
Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at denverdivorceattorneys.com. Thank you and keep a lookout for future live webinars, and I hope to see you again.